Howell Township Zoning Board to be open. Adequate notice having been given pursuant to the New Jersey Open Public Meeting Act in the following manner. First, on January 10th, 2017, a copy of said notice was mailed to the Star Ledger and the Tri-Town News. Second, on January 10th, 2017, a copy of said notice was hand-delivered to the clerk of the Township of Howell. Third, on January 10th, 2017, said notice was posted in the office of the Zoning Board and on the bulletin board in the Howell Township Municipal Building, 4567 Route 9, Howell Township, New Jersey. In accordance with the Fire Prevention Code and your safety, please be advised that this facility is designed with 2 emergency exits, which are on your right at the front and rear of the meeting room. Furthermore, smoking is not permitted in the municipal building. Please take note that this meeting is being videotaped for possible future broadcast on Howell Township TV 77.
Thank you, Eileen. Can we have a roll call, please?
Yes, you may. Mr. Amata.
Present.
Mr. Cardelicchio.
Here.
Mr. Mertens.
Here.
Mr. O'Donnell.
Here.
Mr. Posh.
Here.
Mr. St. Clementi.
Here.
Mr. Turk.
Here.
Mr. Bloom.
Here.
Chairman Nansen.
Here.
You have a quorum.
Before we stand for the Pledge of Allegiance, I just want everybody to just keep in remembrance what happened 16 years ago, September 11th. It touched each and every one of us in some way. We either knew somebody or, just being a patriot of America. The other thing is the hurricanes that have hit both Houston and Florida. Just keep those people in our prayers and our memories. Can we all stand for the Pledge of Allegiance? Pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Mr. Tropoli, swear in the professionals, please.
Swear the testimony you give this evening is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Right, the record should reflect that both Ms. Opke and Mr. Mallon have been sworn to be.
Thank you. Any minutes?
No minutes this evening.
Vouchers?
No vouchers.
Correspondence?
Just what was ever mailed to the members or handed out this evening and left at your desk there.
Okay. Nothing that we need to go over, right?
No.
Okay. Resolutions?
No resolutions this evening.
Okay, we're getting right into it. Application before the board, case number BA 17-11, Louis Esposito, rear and front yard setback variance. Application Louis Esposito is applicant and Louis Rosaria Esposito is owner seeking a rear and front yard setback variance to maintain an existing paver patio, bocce court, and pool in the front and rear yard on premises known as Block 35.52, Lots 6, 26 North Westfield Road. Expiration date December 23rd, 2017. Mr. Esposito, want to come forward, please? If you would, we have you sworn in here.
Raise your right hand. You swear the testimony you give this evening will be the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Please have a seat, make yourself comfortable. Is anyone else testifying in your case this evening?
No.
Okay, very good.
Yes, there's a microphone.
Thank you. Good evening.
Yes, sir. Want to explain why you are here?
Requesting a variance for the pavers that I extended and the bocce court that I have in my backyard because I have an open permit.
Okay, you have an open permit. For
The
what?
pool was put in, and then afterwards we extended the pavers.
Were you aware of the setbacks?
Well, no. What I did is, rather than send a written request or another drawing, I called the township, and it was a misunderstanding on my part that I could extend the pavers as long as were not a permanent structure, and that's what I did.
Okay, was bocce court a permanent structure?
No, it's sand with pavers all around it. I have photos to show you.
Okay. You want to mark those, Mr. Tropoli?
I'm sorry, Ron.
It's got photos.
Do you have how many of these?
pass those up to the board, we'll take a look at it.
And illustrate these as anyone else to the board.
Thank you.
Want to pass them to the staff, and then we'll.
Thank you. Tom needs to initial them too, Tom.
Yeah, whenever those photos come by, you initial those.
Well, you know, I saw you with it, and I didn't realize, I thought I gave it to you, I didn't know you printed it.
Just give the board a moment to review.
Not going anywhere.
We got a lot of folks here.
Thank you. Okay, well, they're looking, okay, going to the drawing, I see that this was done and the drawing was completed 9/5/03, is that correct?
Correct.
When was the construction on the pool?
Same date.
Back in 2003?
Correct.
Okay, so what brought you to this point, you were trying to close out your CO or the
Correct.
permit, correct?
That is correct.
Okay, now, on the drawing, it doesn't show the sidewalks. Mr. Mallon, would the property out to the curb, would that actually, to the bocce court, if you look at the sidewalk is outside the fence?
Yes.
To the curb, wouldn't that measurement go from that curb line back,
Well,
or the
okay,
property line?
For a wall, you have to be 5 feet off of the property line.
Correct,
However, we do allow up to 30 inches for landscaping type of setup. It's hard to say, but it doesn't look like the wall parallel to the street exceeds that 30 inches.
right,
However, when you put a 4-foot fence on top of the wall, then it exceeds the height of the fence.
correct.
And you're allowed 4 feet open. It appears on the pictures that the fence is open, but it exceeds the 4-foot dimension. Looking at the wall and those paver blocks, it's probably 1.5, it's probably 12, maybe 16 inches high at points.
And then
It
that puts the
steps as you come
fence
up.
over 5 feet.
It's over 5 feet, yes.
Okay, now, the offset footage, wouldn't that go from the curb in?
Well, the ordinance says 5 feet from the property line for a wall. It basically says a fence can be from the property line in, is how we read it. Has
Right.
to be less than 4 feet and 50%, 4 feet or less and 50% open. And usually we make it go along the property line,
But if you go from the curb
right?
to that wall, that's more than 5 feet because you got a
Yes.
3-foot
yeah,
sidewalk.
Well, you got a 4-foot sidewalk, and you probably have, just by looking at that, it looks like about 3 feet between the curb and the sidewalk. So you have 7 feet, and then it looks like the fence is on the property line, based upon what I see.
Okay, so he would technically need a height variance, correct?
He would need a height variance for the fence, yes.
Being in the front yard.
That's on the
side.
wall. In the front, he's fine. He's allowed 4 feet. It appears that's a 4-foot fence.
I know, but it's on top of the wall, though.
Not the fence parallel to the street. You have to
No,
step in.
I'm talking the other one. There's
On
2
top of the wall,
fences, right,
as you look at it. There's a double fence in there.
right, correct.
The inside fence looks like it's on top of the wall.
Right.
I don't have dimensions on what that is, but it's probably not much more than a couple of feet. I don't know if Mr. Esposito knows what that dimension is?
The height of the fence on the
For the pla-
driveways?
Well, there's a
driveway
planted
side?
area, I don't have.
In
I
the
just-
planted
I have just
area.
an
Where
aerial.
the plant is, by the bocce court?
Right.
That's
The-
4 feet.
Okay, that's 4 feet, so it's on top of
If
the
you
wall,
come up the
correct?
driveway comes up, and the fence goes up.
I understand, but that's on top of the wall, right? Correct?
The fence isn't exactly in the same place where it was before when I originally bought the house. It was replaced, there was a chain link fence, and we just replaced it with that PVC fence. Because as you go up the driveway, it rises up. So instead of coming down and graded, it comes down like in a step. It's a 4-foot fence all the way around.
Okay, this fence, where it comes right here, does this step down to this fence out front, or does it all just blend in?
No, it steps down.
Right, that's what I'm saying. This fence is on top of the wall, which that's a 4-foot fence on top of a 1 foot. Even if it's 1 foot, it's still 5 feet. It would be considered a 5-foot fence. So technically, you would need a variance for the height of that fence, technically.
I didn't
Am
think
I
that-
correct? Am I correct?
Correct, yes, in the front yard, yes, the height.
Right. So, but the other fence would be all right because it's an existing elevation, correct, Jack?
Excuse me, I'm sorry.
The inside fence would be okay
The
since
inside fence is fine.
Okay.
Well, once you get down the property line, he can do, once he gets set back to the building line, he can go to 6 feet.
Yeah, well, that's
But it looks like it's 4.
a long way to the building line.
Yeah, well, yeah, the definition of the building line, of the front setback is from the property line to the building. That's
Correct.
the problem. So if the setback allowed is 25 feet or 40 feet, let me see, front set, what is it?
He would need a height variance for that,
Okay.
that full length of fence there.
Yes, that's
Okay.
correct,
Okay.
in the front yard. Front yard setback is 25 feet, but it looks like the house is set further back.
Right,
Setback, scaling it's about 40 feet, which means his front yard setback in this case is 40, based upon the definition in the ordinance.
okay. Now, as far as water runoff from the pool, does that run into your neighbor's yard over Lot 5?
No.
We don't have any type of drainage, elevations on the drainage here, so, kind of.
Mr. Chairman, if I could help the gentleman a little bit?
Yes.
Based upon the drawing, the grading plan, it looks like there's a high point 2/3 of the way back from the pool. It drains to the front and rear. Unfortunately, on the drawing, you can't see, whereas the pictures that he showed, if you look, there's a little curb that controls the water. So
Yes.
it diverts the water. It goes out towards the bocce court and out to the street, and then into his backyard to the grassed area. So it
Correct.
doesn't appear that he runs it back into his neighbor's yard.
Okay.
Because he has the curb.
Okay,
But the violation is, anything around the pool has to be 10 foot away,
right,
whether it's solid concrete or pavers.
right.
That's what the ordinance says. And he's, what, 2.3 feet, I think it was?
Yeah,
Yep.
I forget what it said, but it was 2.4.
yes, it's 2 feet, a little over 2
Right.
feet.
And he requires 10.
But see, the bocce court, it looks like the bocce court and that section would be all right if you go to the curb, correct?
Yeah, it's interesting. Do you consider the bocce court a structure?
No.
Well, so,
I'm looking at it, it's not a
right.
structure.
I mean, it's really not elevated. I think the pavers it looks like as the pavers come down, they run into the bocce court,
Yeah,
the water. But it's interesting, we've never considered it. I think if it was built up higher than the existing ground, I think you would look at it as different, but it's not a structure, per se, by looking at the photos. But it is, and it's separated, if you look at the pavers around the pool, it's separated by another wall.
I know, I see that.
So I think once you put that wall in, I think it changes that area of being considered attached to the sidewalk around the pool.
Okay.
But this municipality has always looked at, if you concrete around your pool and then you put pavers, we've always considered that as an extension of the concrete or impervious surface around the pool.
Right. Well, what I'm getting at is, where do we need the variance? Pepperidge Road, does that need a variance for that that's why I'm asking this question.
Well, I think we
Because-
cited it, but the question is whether that is a structure. If we don't consider it a structure, then he doesn't need a variance for the bocce court.
The only way it could be a structure is if you considered the wall as being part of the bocce court. You know, the wall is what
Well,
would create the structure, wouldn't it?
true, but, you know, if he planted flowers in there, you'd consider it a planter.
Well,
'Cause
he
it's less
planted
than-
flower, he's got
Well, he's got
ornamental
them around.
grasses in
I'm
there.
talking about the bocce court itself. If he
Yeah.
put plants in there, you'd consider it a planter.
Right,
There's no plants in there, it's a bocce court. You wouldn't be a violation, because we have always allowed in the front yard, up to 30 inches high, what we call planters. You could do a decorative wall, whatever it is, and we've allowed it. We've never limited it to size, you know, but this one's a little bit bigger than a normal planter, but when you look at it, it could be a planter. But we've already talked about, and I'll list some of the members, but the bocce court's not considered a structure.
okay. My question is, we don't need a setback variance for
For the bocce court.
Pepperidge Road. Because, you know, if you go from the curb into that wall, you're more than 10 feet.
True. But remember, the definition is not from the curb, it's from the property line.
Yeah, but is this the property line, though?
Well,
Doesn't the
Basi-
property line go to the curb?
based upon the survey and what he shows it to the property line. He doesn't show curbing on there.
Okay,
And then he says 50-foot right-of-way. So I interpret on the drawing and the grading plan, that is the property line.
okay. I'm
the
trying to
curb.
clarify that. So we have to go basically from the property line?
That's correct.
Okay, we can't take in consideration the curb?
That's correct.
Okay. Now that that's cleared, so he does need a variance for, regardless, he's got the pavers out there, so
He
he's
needs
gonna
pavers
need
and the fence.
Okay,
Those are the two variances he needs. The
then-
pavers must be 10 foot off the property line, he's 2.4, and the wall can be 4 foot, and it's 4 to 5 feet high, but he does comply with the openness, the 50% open.
okay.
So eliminating pepperidge.
Yes.
Okay, sir. Now, I'll get back to you. So you had contacted the township, you know, the engineering department or code enforcement or whoever you contacted as far as the permits on the pavers. What were you told?
Well, first of all, the pool went in, and the fence went in, and all the
Still
pavers,
needs the wall
the
from
bocce court didn't go in, obviously, and the side where my neighbor is,
Fence over
the
4
pavers were not there, there was only maybe
patio.
3 feet of pavers there.
No, he needs that.
So everything was in, I think they came to inspect, and then afterwards, I called the township and said, can I extend the pavers to my property line and put the court with pavers? And the response that I got was, and it could have been a misunderstanding on my part, because I didn't put it in writing, was as long as they're not permanent structure, you can do that,
Okay,
okay? And so I extended the pavers and left it at that.
okay. Now, did you own the property back in 2003?
I've
or-
owned it since '92.
Okay. So you're the original filer for the permits, correct?
Correct.
Okay. Mika, do you have any, Mika? Mika, do you have any,
Okay, we're doing a little sidebar. So as we look at what variances need,
correct?
for the wall, as you talked about from Pepperidge, he doesn't need that. The wall's got to be 5 feet from the property line. He's 9 feet for that wall,
From the
he-
property line,
from the property line.
the wall is 3 feet.
No, those are pavers. You got to read it. Those are the pavers. There's a step down. The wall, I take it, correct?
No.
in between.
The
Okay, I'm reading
paver,
it wrong. I'm reading the survey. I'm sorry.
the pavers go.
When you look at the grading plan,
He's talking about that, right?
he has it
There's
labeled 3 feet.
You got
So-
the ornamental grasses that constitutes the 3 feet to the fence.
Yeah, you're right. That's correct. You're right.
So, you know, he doesn't have,
The wall's got to be 5 feet, and it's 3 feet.
yeah, it's 3 feet. So it
But-
would require variance for the wall.
That's correct.
On preference.
But it doesn't appear to be that high. Usually you want a 1-to-1 slope from the wall. That's what the ordinance says, and while there's no grading in there, it sure doesn't look like it's too steep.
Okay. So what do you think? Does it need,
I would grant him the variance, just in
Okay.
case. To me, it's not like he's got a 4-foot wall in there. It's probably a block and a half high, approximately.
Yeah, just about a block. Maybe even-
About a block?
Maybe even less than a
Well,
block,
you got a block and then a cap block, so
correct.
it's just about a block, so it'd be 12 inches.
okay. Board members, y'all have any questions?
Does impervious coverage come into play here, Jack, or is this
No.
not considered impervious?
We don't have in our ordinance any kind of requirement for impervious coverage
Right.
in residential zone.
It's coming, but it's not, there yet.
How many years have we been requesting that?
Many.
Yep.
But if you look at it, I mean, he's got a lot of grass area.
No, I know, but he also has area, you know, that goes right up to his property
Oh,
line.
yeah,
To his
absolutely.
neighbors,
Yep.
you know, which. Any other questions from the board?
Has there been any drainage issues over the years?
No, sir.
Okay. That's all I have.
Just have a comment, since these are pavers and they're not structures along the fence, could they be replaced with a paver that has a hold that would stop any water from going in, or is that gonna matter?
Well, that's been a debate for a long time, whether pavers are impervious or not impervious. You have joints between, a lot of times the water goes through there. Some towns consider them impervious, some don't. We have decided that they're impervious. There's nothing in the ordinance that tells you that, but there has been a decision by the township officials that, when I say township, in the, not the governing body, but others, that it is impervious. That's how we've interpreted pavers.
Well, he's got 2 feet of
That's
area
correct.
by the fence to
Well,
the property line.
The key to this is curbing. He's got a little curb there. And remember, the reason for this was, people have a pool, they splash chlorine water, it flows off to their neighbor. Neighbors like to plant flowers or vegetable gardens and stuff along there, and that's why this ordinance came about. The water would run off, go into it, and kill all of the vegetation along, that's why we wanted 10 feet.
Okay,
But we have asked many times for the governing body to make a change, either allow a 2-foot stone trench to collect the water so it doesn't pass off to the neighbors, but we have never gotten anywhere with that.
you know. It's been in the yearly review for many, many years.
Yes.
So just a question, Mr. Esposito, then, your neighbor that's on the other side of the pool,
Lot 5.
any complaints, are they,
No,
nothing
Not
at
at
all?
all.
And we have no record from the township level that anybody called to complain.
Okay, okay.
Any other questions from the board? Any other further questions from the professionals?
No.
Seeing none, can I have a motion to open to public?
Motion.
Motion by Mr. Merton. Seconded by Mr. Carlicchio. All in favor? All opposed? At this time, if anyone has any questions or comments of the applicant, please come forward. Seeing none, can I have a motion to close?
Motion to close.
Motion by Mr. Cordelicchio, seconded by Mr. Armada. All in favor? Aye. All opposed? Seeing none. What's the pleasure of the board?
I'd like to make a motion, Mr. Chairman, pertaining to case number BA 17-11, Louis Esposito seeking rear and front yard setback. Motion to approve both variances, one for 26 North Westfield and one for Pepperidge Road.
And that's for the fence and the wall, correct?
Correct.
Okay. Inside yard setbacks.
Yes.
Okay. Do I have a second?
I'll second it.
Seconded by Mr. Armada. We have a roll call, please.
Yes, you may. Mr. Amata.
Yes.
Mr. Cordelicchio.
Yes.
Mr. Mertens.
Yes.
Mr. O'Donnell.
Yes.
Mr. Posh.
Yes.
Mr. San Clemente.
Yes.
Chairman Nansen.
Yes.
Motion carries.
Good luck.
Thank you.
Can I have all the photos back? This is all they are, Mr. Chairman. Okay. Okay, next case, case number BA 17-06, Howell Open Land and Preservation of Environmental Hope, Interpretation of Zoning Ordinance, application of Howell for open land preservation of environment as applicant and 41 Rudolph LLC as owner seeking interpretation of zoning ordinance. 41 Randolph LLC is proposing a one-story warehouse with multiple tenants of 123,309 square feet with driveway and 136 parking spaces for use by large trucks and semis. Applicant is seeking a formal opinion interpretation, whether the 41 Randolph LLC application for development should be transferred to the zoning board. This application was originally scheduled for July 24, 2017, when it was carried to August 14, 2017, with no further notice. On August 14, 2017, it was carried to September 11, 2017, with no further notice. Expiration date, September 22nd, 2017. Well, Mr. Tropoli, I would like you to intervene at this point and kind of set some ground rules.
Good evening, everyone. I want to point out a couple of things. This is an application for an interpretation, and I do note for the record that there's a number of members of the public, and before we begin, or as we begin, I'm going to ask the attorneys each for and against the application to introduce themselves and their respective clients and who they represent. Because this is a legal determination, there is no public participation whatsoever. You're certainly able to sit, listen, but you will not be able to participate. The governing statute in this case, and again, I'm certain that the attorneys won't disagree with me, would be under the MLUL under 40:55D70B. So your task tonight is to hear and decide a request for an interpretation of the zoning map or ordinance, or for decisions upon other special questions upon which such board is authorized to pass by any zoning or official map ordinance in accordance with the act. So your role tonight is limited. It's to interpret. You're not here to address the merits of the case, whether you feel the case should go forward, whether you like the application or don't like the application. You're simply narrowing your inquiry into a legal determination, a legal decision based on the ordinance, based on the application before you. And that's basically what you'd be doing tonight. I do know that there's a number of letters that have gone back and forth by respective parties, and I would expect that there'll be legal argument, and essentially there'll be an interpretation. You will be making a legal determination based on the law that you're presented with, the ordinances, and the arguments of counsel. And with that, Mr. Chairman, I'm going to ask the council who are now seated to introduce themselves so we know who's here and whose clients they represent. I'll start with the applicant, sir.
Yes, good evening. I'm Bill Potter with the law firm of Potter & Dixon, and I'm representing the applicant Hope Howell for Open Lands and Preservation of the Environment. And we have several members of the group here. I think you see them. Could they just stand up and identify themselves?
That's fine.
Please rise. And over here is Ms. Dawn Van Brunt, who is the leader of the pack, so to speak, of Hope. And I would ask if Your Honor, if the board would consider allowing at least Dawn Van Brunt to make a statement on behalf of the group. I think it's important for...
No.
If it's public,
I have
no.
to, Mr. Potter, as much as I'd like to, again, strictly limiting this as a legal determination, it's a legal argument.
Well, I do think also we have a expert planner here, a witness, Mr. Pasolano, who would like to testify as to the planning implications and the proper method of planners to interpret the ordinance in a manner consistent with what we have. So I would at least like him to be sworn in and testify.
yes,
That's
sir.
fine, but let's get the appearances of counsel on the record.
Okay,
And
I'm
then I'll
sorry.
swear the witnesses in, because obviously it's your burden to move forward. Counsel?
Good evening, Board. My name is Lanny Lombardi. I'm from the law firm Cleary, Giacobbe, Alfieri, and Jacobs. We represent the Planning Board applicant, 41 Randolph Road LLC, to which Mr. Potter is addressing the zone in which the property is located.
Good evening. Paul Schneider from the law firm of Giordano, Howard, and Ciesla. I'm here tonight on behalf of Arnold Steel Company, the owner of lots 3 and 2.01 in Block 38, which is within 200 feet of the property that's the subject of the application, and also in the SED zone. I'm also representing Felix Flaster and the estate of Lawrence Katz, which owns lots 2 and 3 in Block 5, also in the SED zone and within 200 feet of the property that's the subject of the application. And I'm representing TPL Realty LLC, the owner of Lot 1 in Block 38, also in the SED zone.
Now, are they in any part of the 41 Randolph LLC?
They are not.
Okay.
Chairman, if I may, just because Mr. Potter has indicated that he intends to swear in and have testimony taken from his planner, we want to note our objection to that. We feel that any testimony that would be provided by the planner would be going to the substance of the application, addressing it from a planning standpoint. So we would feel that there wouldn't be any need for testimony from an expert for this board to properly exercise its powers to interpret its own ordinance.
Mr. Tropoli?
Out of an abundance of caution, and having been in front of the appellate division when the board has curtailed in the past testimony from someone who's proffered as a witness, I would say that while I note Ms. Lombardi's objection, I believe that the applicant should be permitted to present the testimony of his professional. However, I'd point out that it absolutely has to be limited to statutory construction and things of that nature. If it starts going into areas such as the size, the height, the traffic, the this, the that, which a planner normally does, that's not proper. And I would presume that Mr. Potter understands if we're talking about statutory construction and things of that nature, an ordinance interpretation, it's an opinion the board can be free to accept or reject. But we don't want to get into the merits of the application. That is not the function of this board this evening in reviewing your application.
I understand, Mr. Tropoli.
Tropoli, that's fine.
Tropoli.
That's okay.
That's okay.
I've been called worse.
I'm sorry to hear that.
So that would be, Mr. Chair, my opinion on that.
Okay.
So I would permit it.
Mr. Chairman, we have submitted two rather detailed legal letters to the board, one on May 10th and the other on July 19th. Those are exhibits that Ms. Rubano has entered into the record, so I won't read from those directly to you, but
before we do that, you want to go ahead and swear in your professional here?
Okay.
Mr. Potter, you mean June 19th? You said July 19th, I think.
Well, I got it July 19th.
Okay, I don't have that. Okay, fine.
July 19th.
Okay,
Sir, would you please
That was
stand?
one of the links.
Swear.
okay.
You swear the testimony you give this evening will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Yes, and may we have your name for the record, please?
Michael J. Pesolano, P-E-S-S-O-L-A-N-O. Licensed professional planner in the state of New Jersey.
Mr. Potter, before he testifies, we need to qualify him whenever you get to that point.
Would
We'll
you
need
like
to
for me to qualify my witness right away and have him testify at the present time?
No, go ahead, follow through with what you're doing, but before he testifies, we need
Of
to
course.
qualify him.
Very good. As you know, I represent the group called HOPE, and the reason that they have retained me, and also Mr. Pesolano, is because of their concern for the jurisdiction of the various boards, the planning board versus the zoning board. As you know, if a use is considered permitted, there's very little consideration of off-track impacts, especially traffic. And that's one of our main concerns, given that the 41 Randolph development has 123,000 square feet of warehouse space and 136 bays for large tractor-trailer trucks. So my clients are very interested not in the legalistic issue of interpretation, but in the real-world impact of whether this zoning board will review it under your special reasons category and require variances in which you would have to look at the positive and negative factors. And most importantly, you'd look at the off-track impacts. So,
Mr. Potter,
Yeah, no.
I just need to stop
Have I
you.
done
Again,
it?
I don't mean to get you off your target, but the issue here that you narrowly framed was whether or not the purpose of the ordinance is met by having this application before the planning board. It was my understanding that the preamble of the ordinance in the SED zone is what you are essentially hanging your argument on in terms of whether or not infrastructure, including railways and major roadways, are readily available to the applicant. I do understand and appreciate the fact that you need to get into certain areas just so that there's a context to understand this, but I would just ask that we just jump right into the meat of it so that the
Okay.
board can understand why they're here and why they're listening to the argument.
okay, thank you very much.
You're welcome, sir.
I apologize for going too far already. We believe that this application, 41 Randolph, belongs in front of the Zoning Board of Adjustment because the purpose clause of the ordinance, section 188-79A, says in so many words that the SED zone is to provide for a variety of economic development opportunities in areas of the township where rail and highway infrastructure are readily available. And it's our position that based upon the master plan, which defines these terms pretty well in terms of what is highway and what is not, that there is no highway infrastructure readily available. There are very small two-lane roads, which are really not made for tractor-trailer trucks to be going up and down them, and the people live next door to those, on these narrow roads, and so we think that there's a very important issue for this board. As far as the rail infrastructure, there is one small rail line to the west, but it is not adjacent to the property, and therefore we don't think that it is readily available either. Now, the appellate division in the trust company case of 1990 interpreted the question of whether or not the purpose clause is part of the statute, part of the zoning ordinance. And the court, and this is described in my letter of July 19th, said that if the purpose clause, that it is always the function of the zoning board or the planning board to follow the legislative intent of the township committee. The purpose clause tells you what the intention is. And the question before the board here is this purpose clause sufficiently specific and precise that it provides guidance in terms of whether or not a particular use is in conformity with the ordinance? We think that the question of whether or not highway infrastructure and rail infrastructure are readily available is a precise enough guidepost for the board to make a decision. And I won't repeat the other arguments that are set forth in my letters. I would like to get Mr. Passolano to testify at the present time.
Okay. You want to qualify, Mr. Pistolano?
Mr. Passolano, would you give your full name and address?
Yes, and Michael J. Pessolano. I'm a licensed professional planner in the state of New Jersey, licensed originally in 1984, and have been practicing professional planning ever since, continuously. I'm also a member of the American Institute of Certified Planners, which has rigorous continuing education requirements to keep its members on the front edge of planning trends and knowledge. I have served my over 30 years as a professional planner, principally and actually solely with municipalities in mind. In other words, never a regional planner, never a county planner, but in the municipal trenches, so to speak.
We accept your credentials.
Are there any, is there any voir dire by opposing counsel? Of course, Ms. Lombardi, your objections for the record. Does anyone have any questions of the
No.
credential-wise?
No, sir.
Very good. Accepted.
Thank you very much. I would ask if Mr. Passolano could testify in a narrative fashion so that he can go forward in a much unbroken manner, if he may, please. Mr. Passolano, do you want to testify as to the proper interpretation method on the ordinance?
Yes, thank you, Mr. Potter, and good evening, Chairman and members of the board, staff. It's a pleasure to be here, and really, for a planner, a great pleasure not to have to use the words negative criteria or positive criteria in my testimony for once. You will not hear that from me tonight, because as Mr. Tropoli pointed out, this is a narrow focus mission of the participants tonight to sort out whether or not the language of the ordinance is authorizing the proposed use or not authorizing it. And to prepare for tonight's presentation that you're about to hear, I reviewed the application at hand. That's all I'll say about the application. I looked at the township zoning regulations relevant to this matter, the master plan materials, the site and the general neighborhood of where we're talking about. In other words, gained a familiarity with the subject material. The site, as you know, is located within the SED district at 41 Randolph Road. And the purpose of the SED district I found to be the specific purpose of accommodating generally large-scale development with highway and rail infrastructure. Where did I get that notion? Well, I got it right out of the preamble, which specifically states that uses are to be accommodated where rail and highway infrastructure are readily available. And we'll get it more into detail with evaluating those terms. But as you know, an application for a warehouse has been submitted to the planning board. This application, by hope, is to sort out with you all whether or not the use is indeed permitted, based on the language of the preamble that introduces the list of permitted uses that are in the SED district. The board planner has weighed in. Other interested parties have weighed in written materials. We are doing that in kind with my testimony to weigh in as to the reasons why we think this application is not ripe for being considered a permitted use. The backdrop for all of this discussion is something you rarely get into in your day-to-day application processing. And I can say that having been zoning board planner for half a dozen municipalities throughout New Jersey, you rarely see this kind of application. So it's unusual. So bear with me as I set the stage for what I think is the proper calculus for figuring out whether or not this use is to be permitted. The municipal land use law, affectionately abbreviated to the MLUL, provides a basis and authorization for zoning. That's where we get the power in the local communities to adopt zoning that's unique to the community's needs, but within the broader scope of the state enabling legislation, which is the municipal land use law, also called the Zoning Act. Case law has verified that zoning is indeed a legitimate exercise of the police power. So there's no dispute that municipalities may zone, but it gets tricky after that. And by tricky, I mean that the municipal land use law and the ensuing evolution of case law to sort out what the municipal land use law meant in certain cases has led to an understanding that zoning in a community needs to be linked to its planning. So every community typically has a master plan, and once a master plan is done, usually it's a big elaborate thing, public hearings, a lot of data looked at. Then every so often that master plan is re-examined. The planning board does this, so this is not a familiar territory for a zoning board, but planning boards conduct a re-examination of the master plan. The statute used to require that to be done every 6 years. It was amended to be now once every 10 years. What's the significance of that? That aspect is what helps a community's zone development regulations be in sync and in touch with the needs of the community, the population, the issues, planning issues, policies, not just at the local level, but at the county, the state level. All of that gets looked at in these periodic re-examinations of the master plan. The purpose of that is so that any things that are found to be out of match with the original master plan can be identified and then brought into alignment so that the zoning is matching the master plan moving into the future. And the courts, through numerous cases, have reinforced that notion that the master planning for a community is the foundation for land use regulation or the exercise of that police power I mentioned before. It's a formidable power, and so for it to be supported consistently throughout the state within the context of the MLUL, planning first, then zoning actions to be advancing what the planning policies of the community are. So that's the umbrella backdrop for consideration of the rest of it. 45:D-89.1 is the section of the MLUL that requires a master plan reexamination report. And it provides for several steps that need to be taken to say you've reexamined your master plan. I won't go into them, but rest assured they are there in the statute in black and white, and master plan reexamination reports, your board's planner will affirm, has to hit on certain points to be considered a valid master plan reexamination effort. I evaluated the township's inventory of planning materials and did not find that a true reexamination has taken place within the last 10 years. There was a reexamination done in 2005. We are now in 2017, 12 years later. The 2006 land use plan for the community was amended in 2007, and at the end of that was a page that had a title on it, Reexamination of the Master Plan. And what followed that title was just a bunch of recommendations for tweaking the zoning here and there. It did not take into account evaluating the circumstances, conditions, changes from the last master plan reexamination report. All of those are in the statute and need to be addressed, at least in language, in a master plan reexam report for it to have that title, in my opinion. So with the last re-exam report not being within the last 10 years, there is a rebuttable presumption, 50-cent term, that means that the zoning ordinance is sort of on shaky ground. There's a rebuttable presumption that the zoning ordinance is no longer valid and more subject to challenge because it has left that pedestal of foundation that the master planning for the community provides and the MLUL requires. So it's gone too far, and that creates, in my mind, a reason to hold off a second and not plow forward with a plan, a zoning scheme that is not based in master planning as the statute requires.
Excuse me. Mika?
Yes, Mr. Chairman. Sorry, Mr. Piscolano, but I just wanted to tell you that the Planning Board did recently adopt a master plan re-examination report in May 2017.
Oh, that's terrific.
Yeah.
Okay. Well, disregard what I just said in the past few minutes then. I did not know that. Was that posted on the township's website at all?
Everything on the website is not up to date.
No.
There probably have been several that are not on there.
Okay. My apologies for going down that road. We need not focus there. It is not the sum and substance of our case.
It was an interesting exposition nonetheless.
It provided fodder for what I'm about to say next. We still recognize the connection between planning and implementation of that planning through zoning mechanisms. In other words, zoning ordinances. In this particular SED zone that we're talking about, the southern part of the community, when it was adopted, if that was expected to have rail and highway access available to all parcels, that clearly has not happened. No apparent plan exists in my awareness to make that happen.
Well, I want to, you just made a statement, made it available. That's not what the ordinance states. The ordinance states readily available.
That's correct.
That's correct.
Not available to each parcel.
We see readily available as being the only meaning that has meaning in the context of what we're talking about tonight. And I'll get to that in a little bit, Mr. Chairman. I appreciate you wanting to keep me on course with the focus. But if I may continue, I will explain. I want to point out that the 2007 land use plan recommended reduction of this particular SED zone to eliminate residential lots on the north side of Randolph Road and to put them in the ARE-6 zone. That was not acted on, as far as I'm aware.
But see, that's recommendations. That's not,
Okay.
brought into fruition through the master plan.
It is a sidebar to the main event that we're coming up to, so stand by, please. What is important is that the land use plan of 2007 mentions the environmental sensitivity of this particular SED district due to a Category 1 stream traversing the district at the north end.
Chairman,
We're getting into the application here.
No, we're not, really. This is dealing with the SED district as a whole and not focusing on the parcel.
I'm just going to advise the witness one more time to just please, and I know it may be difficult because there is some context that you'd like to give, let's limit it to the ordinance and the application of the ordinance as requested by the applicant.
Well, I think he is just trying to give context, but I will ask the witness to, so to speak, get to the main event.
Thank you.
On to the role of the preamble. At the administrative level, township, local communities have staff who will interpret the meaning of the zoning ordinance, usually the zoning officer or the construction official. They are charged with looking at the list of permitted uses and making a judgment. Is the use in the list? If so, generally, they will say, yes, it's a permitted use. In practice, these officials are typically not guided by preamble language, though, for a zone district, nor should they be. because of the subjectivity involved. Notice we're having quite a discussion already about meaning of terms. However, at the review level, in other words, at the meeting of this body, the Zoning Board of Adjustment, and in the courts, considering interpretation requests, look more at the entirety of an ordinance, including and especially the purpose and intent of the regulations in resolving disputes over zoning regulation. In my reading of Section 188-79A, the intent is clearly expressed in that paragraph. The critical phrase here is, I quote, "where rail and highway infrastructure are readily available." Now, naturally, every parcel in the township is some distance from something, some distance from a highway, some distance from a rail line. So for this to have any meaning in the context of what we're talking about tonight, it must be interpreted, in my opinion, to mean both adjacent or within the power of the developer to access in connection with a proposed use of the land, and now, or realistically achievable within the time frame for completion of the construction. The nexus that exists between zoning regulations and the master plan is not something that I find very disputable. The land use law is set up, court cases have validated that you have planning first, then zoning regulation.
Mr. Pestilano, could I interrupt you and ask?
Yes, please.
Does the 41 Randolph LLC site have a highway infrastructure adjacent to or readily available for?
It has
serving-
neither.
Neither rail nor highway infrastructure?
That's correct.
Okay, thank you.
You're welcome. I want to, before proceeding, just point out the framework for the flow between master plan and zoning. I did not go as deep as I should have earlier in my introduction of that material. I want to point out that variance granting agencies are required to find that the granting of relief does not undermine the intent and purpose of the zone plan for the municipality. Communities are required to re-examine their master plan. We've already covered that. ZBAs, zoning boards of adjustments, prepare annual reports to the governing body to provide timely feedback as to whether certain regulations might be out of sync with prevailing conditions. Zoning ordinance preambles frequently include language from the applicable master plan to emphasize that the purposes are consistent and thus valid. If preamble language is insignificant to the purpose of the zoning regulation, then it would not need to be included because the adopting ordinance itself typically is introduced with preamble language that does not get included in the actual zoning ordinance. However, when the preamble language is included, that must signal to those interpreting the governing body's intent that such wording is material to the interpretation at hand. In the review of interpretation appeals, any applicant may file such an application, which Hope, my client, has done. In reviewing such appeals, according to the Cox Treatise, New Jersey Zoning and Land Use Administration, deciphering the intent of the legislation is primary to the analysis. In my reading of the legislation in Section 188-79A, the intent is expressed in very clear and unambiguous terms that the fundamental purpose of the SED district is to accommodate the listed permitted uses where rail and highway infrastructure are readily available. The language doesn't say infrastructure can be close or nearby. The only meaning that makes sense here is for it to be truly available to the subject property by being adjacent or reachable through easement or land assemblage. The ordinance language does not even say available within a specified distance of the property. The language does not say rail or highway infrastructure. It therefore necessarily means both, in my opinion. Interpretation of an ordinance in favor of an outcome that is not aligned with the fundamental purpose of the subject zoning district may not withstand judicial scrutiny because zoning must be designed and remain designed to advance the purposes of the zone plan. That's why I said all that stuff before, leading up to this. There is a connection between community planning and the implementation of it through zoning regulation. The purpose of the zone plan in this matter has been articulated clearly in both the zone plan and the ordinance, section 18879A. Therefore, I must conclude that the Zoning Board of Adjustment may find that a parcel in the SED district that does not have both highway access and rail access for moving freight is not ripe for development. The situation is substantially similar to a parcel of land zoned for various uses but lacks realistic access, requiring some form of relief for the lack of access to be granted in order for land use approval to be authorized. In my experience, generally where required connectivity to infrastructure is lacking, landowners and developers historically have taken steps to connect their development parcels through land assemblage or easements to make that connection with the infrastructure needed to support it. It appears that the subject SED district area that is oriented to Randolph Road is so remote from any highway that land assemblage and or easements are unrealistic remedies. In my opinion, there is not a valid basis for approving land development at 41 Randolph Road without some form of variance relief. I believe the township,
And which body would grant that relief?
the Zoning Board of Adjustment.
The Zoning Board of Adjustment. Thank you.
And in closing, I believe the township governing body should also review this matter. Thank you for your kind attention.
Mr. Chair,
Yes, sir.
just for the purposes of the record and to keep things clear, I would recommend that the cross-examination begin now.
I would.
And then we'll follow up with any questions you may have of either your professionals or from the board. So I'll submit to whoever, Ms. Lombardi, would you like to lead off?
Yes, that's
Ms.
fine.
Lombardi?
Thank you,
Okay.
Mr.
Thank you.
Tropoli. I just want to make sure I'm pronouncing your name correctly. It's Pasolano?
Pasolano.
Pasolano.
Thank you for asking.
Okay. I just want to clarify, from your testimony, though, there's no dispute that the subject property is within an SED zone, correct?
Correct.
And there's no dispute that the use that is being proposed is a warehousing and distribution type use? You're not disputing that?
I don't know if we can go there. We've been asked not to cover the specifics of the application. But yes, if I'm allowed to answer that, that would be my answer, yes.
I think that's the affirmative.
Okay, and you would concede that that is listed within section 18879, section B, which is entitled permitted uses, this ordinance? You would
Correct.
concede it's listed within that?
Yes.
Okay. Now, I just want to clarify, since, I'm sorry, it's Ms. Apte? Ms. Apte did clarify that the reexamination report had been approved by the township in May. So are you conceding that that there's no issue with regard to this ordinance as it pertains to reexamination by the township and it being in conformity with the master plan?
I would like to see that reexamination report before giving you a definitive answer.
I think that's a no.
Okay. Is that a no?
Yes.
You're saying subject to what, that you would be submitting something to the board after the fact, or?
Subject to my awareness of the
Okay,
content of
because
that
it was issued
document.
in May of 2017, so that's
I
quite a while
accept that
ago.
the exercise was done. In terms of the content as it relates to what we're talking about, I have no awareness of what it says.
Okay. You indicate that, also, I want to make sure that you don't have any dispute that there is a railway that does traverse this particular area of the SED zone to which this property is located in. That's correct, right?
Yes.
All right. And I guess based on your expertise, you indicated that you feel that there's nothing, that the rail and the highway infrastructure that's listed within the purpose section of the ordinance is not available. You're saying that it's not even a situation of readily available, you're just saying it's not available. Is that your testimony?
I interpret the language in the preamble to insist that it be readily available.
Okay, and based on your, I guess, expertise then, what would be an estimated distance, I guess, that you would define then to say that it's readily available?
It's a hard question to answer with certainty, but let's say an application is in front of a board and an applicant can represent that through an easement that they're about to purchase would connect them with the cited infrastructure. That would be a reason for concluding that it's readily available through that means.
Okay, I want to make
In
sure
my
I understand
opinion.
what you're saying. Are you saying that therefore that only a property that would be adjacent would be something that you would define as readily available?
In this context, absolutely.
Well, I don't know what you mean when you say in this context.
In the context of the language of this section of the zoning ordinance.
Okay, so your testimony is that only properties that are immediately adjacent to, I mean, I'll refer to the railway since you are conceding there is a railway that does traverse this entire zone area that we're speaking about.
I did not say that in my testimony. It is at the western edge of this SED district, barely tangent to the entire zone. Just for clarity.
Okay. You're saying that this would only, that only properties within this zone that are immediately adjacent to this railway would be properties that would be conforming with this zone?
That is exactly what I'm saying. That and rail and highway. There is no highway anywhere near this
Okay.
SED district.
Again, let me ask you the question about distance then. When you make a test, you've held yourself out as the expert and make a statement that there's no highway anywhere near. What are you basing that testimony
I
on?
regard Route 9 as something that qualifies as a highway. The road that serves this property's frontage is a local road. It's a two-lane road.
Okay, my
None of
question
the
is just
characteristics
narrowed
of a
to
highway
what you define as,
exist on that stretch of road.
what you define in your expertise as near, or you said nowhere near, so I guess what would you
To
define
prove
as
beyond a
near?
doubt, it's not adjacent. It's nowhere near a highway. As I said in my testimony, all parcels are some distance from a highway, but for the language we're talking about to have any meaning, it really has to be adjacent to it for it to have any sense whatsoever. To just randomly say near doesn't achieve any planning purpose.
Okay, well, in your expertise, I guess, what would you be interpreting the word readily to be then?
That you can achieve it now.
Now meaning in time, or, I don't know what you mean when you say now.
That means the property owner has the means to make it happen available to them now. They can engage with another landowner to buy a piece of land that lies between them and the infrastructure. They can purchase an easement, which is commonly done, as you know, in developing properties that are not right adjacent to where they need to be.
Okay, and would you say then that if, let me rephrase that. If you're providing testimony saying that this permitted uses that are listed within this zone would only be available to properties that are immediately adjacent to the railway, and I guess from what you're saying would not be available to any other property from a highway standpoint, how does a property within this zone, in your opinion, satisfy the permitted uses then?
It's not my work. I did not create the zoning ordinance. I have created an interpretation that I've presented tonight that tells me it is a disconnect with what you're asking about.
But you don't dispute that the permitted uses listed within the zone are abundantly clear?
The list reads well
Okay.
and clearly.
You provided testimony that you said that you felt that the purpose of the ordinance is material to the board's determination of whether or not the proposed use of the subject property's application, whether or not it would be something that would qualify. What are you basing that testimony on?
That the purpose is important?
That you're presenting testimony to this board that the purpose language of the ordinance is, you defined it as being material
Yes.
to their interpretation of whether or not the proposed use of the subject applicant qualifies under the permitted uses that you're conceding, as you said, reads well. So what are you basing that opinion on?
Because it's specific and unambiguous language that directs how this zone is to unfold. It is to be populated with developments that have access to both rail and highway infrastructure. I can't see it being made any more clear that that is the intent of the legislation.
Well, it's safe to say that it doesn't say that it's a mandatory requirement, right? It's not listed within the ordinance as being a mandatory requirement.
That's not my testimony. My testimony means it is mandatory that both of those criteria be satisfied.
Okay. That's your interpretation of Section A?
Yes.
Okay. I have no further questions.
I have a few questions, if I may. So I believe you testified that the SED zone permits the 22 permitted uses, provided that they have this ready access to transportation. Is that correct?
I must have missed something. I never used the number 22, so I don't know where
You mean
that
it's not 22 permitted
testimony
uses?
comes from. Perhaps it is, but I did not enumerate the number
Do you have the ordinance handy, sir?
of uses.
Do you have the ordinance handy?
Mr. Chairman, I don't think there's any dispute about the number of uses that are listed in the ordinance. I mean, we can take official notice of the number which appears in the ordinance itself.
I think he's already testified that is, warehousing and distribution is a permitted use within that zone.
And the requirement, I believe you testified that the requirement for this ready access to the highways and rail applies to all of the permitted uses.
Yes.
So, therefore, under your interpretation of the ordinance, there's no use of the subject property that's permitted without a variance. Is that correct?
That would be correct. Except those parcels that do have access to rail and highway, wherever they might be.
My question related to the subject parcel.
Okay. Yes.
And,
I think he's answered the
concur.
question.
Yeah.
okay. In terms of you were describing consistency with the master plan and the failure to have adopted a re-examination report. I believe you were testifying about that because you thought that had some relevance to the board's consideration here tonight. Is that correct?
Yes.
Did you contact Ms. Apte before coming here today to determine when the planning board had last adopted a master plan re-examination report?
Nope.
Would you describe all of the efforts you made to determine whether there was a recent master plan re-examination report before coming here and testifying before this board that there was none?
I looked at the township's website.
That was it. Please speak aloud so the record can hear you. That was it?
I looked at the township's website.
And that was it?
Yes,
No Open Public Records Act requests?
correct.
No calls to any township officials?
I believe he's answered the question. He did not consult anything but the
I
website.
just want the record to be clear.
Shall we go through every other possibility? as
No,
to how
He could have answered the question in less time
Okay.
than your objection took, sir.
Okay, it's already been answered.
You would agree that it's the planning board and not the zoning board that's empowered by the MLUL to determine whether an ordinance is consistent with the master plan?
Yes.
Did you make any effort to...
Excuse me, Counselor, at the time of adoption consideration, the planning board is asked for its opinion on that matter.
And did you make any effort to determine whether the planning board made such a determination prior to adoption of the SED ordinance?
I did not.
You would agree that there's nothing in the purpose language, it doesn't use the word adjacent to highway, is that correct?
That's correct.
Or any variation on that word?
Correct.
It doesn't use the word adjacent or any variation with regard to proximity to rail, is that correct?
Correct.
It does not use the word, you can get there by easement or any variation on the word easement, is that correct?
Correct.
It does not use the word assemblage or any variation on the word assemblage, is
All
that
this has
correct?
been testified to previously, Mr. Chairman.
This is cross-examination, sir.
Yes, sir.
Cross-examination, and I think, Mr. Chair, the
Yes.
questions are appropriate for cross-examination.
And would you agree that from the subject property, you can get to highways by public roads?
Sure.
I have no further questions. Thank you very much.
Thank you.
Chair,
Hey.
members of the board, questions?
Mr. Mallon, I'm going to let you go first.
All right.
I just got one question to my professionals. With this saying readily available and being, it's not a strict, hard, I guess, language within that ordinance stating that, it's readily available. Would that be a variance or would that be a waiver at the time?
Well, first of all, you got to look at the history of the zoning ordinance and how we've done it. At one time, pretty much most of the western and northern part of the township was SED, or at that time, industrial. Had ability to get rail to it, had highway access and major collector access. And it's gotten smaller and smaller and smaller, but it still concentrates really around the rail line, wherever it goes, and can be extended. Readily available is a very important interpretation. The planner takes one interpretation. I believe the township took another. I think the township kept it to be in the vicinity so it could get available, as Mr. Schneider kind of implied. If you also read into our ordinance, I think if the township wanted it to be adjacent or directly on frontage, it would have done like it's done other uses in the municipality where it stipulates, must be on a major collector. We do that specifically for schools. That's one example it is. I think gas stations is another one when you deal with conditional uses. They specifically tell them where they got to be and what kind of access they have to have. I think it's very important, so you have to know what our ordinance, when you read our ordinance, and how it's been interpreted. I can tell you this, in my experience, and I've been here 30 years, that we've always interpreted readily available to be in the vicinity. Doesn't mean but they have to be able to get to it. And the Lakewood Farmingdale Road is not far from this property. We've used it for years. My report shows that the steel company, Arnold Steel, has used Randolph Road for years. They've been there probably almost 40 years, and they've used that road. They have tractor trailers and things going in and out of there. But if this goes to the planning board has the right to request improvements to roads. If they don't think it's substantial, they get into traffic reports. That's what they do. But normally, when we read, and it's always been my experience, and you look in the Cox book, I'll let Mr. Apty go into it also, but we usually look at the determination, permitted uses, not permitted uses. If it's permitted in the ordinance, it's permitted. If it's not, it's prohibited. In this case, warehousing is permitted, it's listed as one of the permitted uses, and that's what how we've always interpreted it. So I really don't have a lot more to read into it. It's really how we define readily available. I can tell you how the township has done it in the past. I don't think it's ever come to the zoning board to be able to do that. Maybe that's something we might have to interpret tonight. I have no further comments than that.
Mika?
I guess going by what Mr. Mallon also said, the interpretation is always done on what's permitted and what's not permitted. And the list of permitted uses, this type of use is permitted. The question here was whether it's adjacent or readily available if they fall under the same criteria. The case law does define that when we are seeing whether the use is permitted or not, you look at the list of permitted uses as defined in Cox. I do agree that the intent is important, but to be specific as to which ordinance it should follow, we always follow the specific definition, what's permitted or what's not.
Okay.
Thank you.
Are there any questions?
From the board,
Or from the
do you have any questions?
or the board's professionals?
Yes, I have a couple. Mr. Malone? Sure. Are you a planner or an engineer?
I'm both, sir.
Okay, good. Congratulations.
Okay.
You can testify as to both then. When you said that for 30 years, this ordinance has been interpreted in a certain way, has there ever been, in your experience, a request for interpretation as to whether or not that was a correct interpretation?
I think I stipulated it's never come before this board.
Okay, so this is the
But
case
it
of
has
first-
always been interpreted readily in the vicinity, but not directly adjacent or not in front of.
Okay, and how do you interpret the word "in the vicinity," which does not appear, of course, in the ordinance?
Well, in the vicinity, readily available, that's why the zone was set around the rail line and the highway line. That's how they set those zones.
Where is the highway next to the SED
Well,
zone?
readily available, they would consider a major collector of Lakewood Farmingdale Road, which is, I think, about 1,000 feet, not even, to the property. They would consider that's a major collector, runs highway, runs from Lakewood up, actually runs to 295, provides access there.
Does it go past residential properties?
Oh, there's residential properties. I don't know if there's zoned residential properties along. I'd have to go look at the zoning to be exact, but I know there's homes directly adjacent to Lakewood Farmingdale Road, yes.
And Randolph Road that is a sub-collector road, is that not the case?
That's correct.
It's a two-lane road without any shoulder, correct?
That's correct.
And the rail line on the western edge of the SED zone, that does not have a siding or a loading platform of any kind, is that correct?
That is correct.
Thank you. I have no further questions.
Questions of our board planner?
I don't have any.
No, thank you.
Questions from the board?
Yes. So we are deciding if this property is readily available, or has readily available rail service and what this gentleman calls a major highway. That's what we're deciding here?
That's correct in my interpretation.
Right.
Thank you.
I would disagree strongly.
So would I.
What you're interpreting is whether or not the proposed warehouse use is a permitted use under the ordinance. That's what
I think
you're
it's
deciding.
smaller than that. The way I understand it is whether it belongs in front of the zoning board or it goes to the planning board. And the criteria for that decision is rail availability and
Well, I would strongly disagree. I think perhaps we're close to the point where the attorneys can
Yeah.
give legal arguments.
Well, yes, I think what I would propose at this point in time is wrapping up the applicant's case, applicant's witness. If there's any further questions of the applicant's witness, I would ask the board to submit them now. If there are no further questions from the board, then counsel, the opposing counsel can give their legal arguments, and then subsequently the board can make their legal determination. So really, right now, it'd be for questions only, and after the conclusion, when all parties give their closing arguments, then that'll be ready for decision.
Okay.
Mr. Chairman.
Seeing it's almost 9 o'clock, can we take about a 15-minute break for purposes?
You're the chairman.
We're going to take a 10-minute break. The board will reconvene at 9:05.
The zoning board will now reconvene.
Wait for Mr. Tropley to get back to his post here. Before we resume, got a few little house cleaning issues to take care of real quick. Mr. Tropley.
Yes.
As far as, I gotta find my,
Calendar.
okay, case number BA 17-13, Stavola Leasing LLC. Mr.
Yes.
Tropley. Mr. Gazarovski.
Yes, the council, would council come forward on that, please? Yes. Yes, good evening, Mr. Gazarovski. Thank you. And Mr. Butler.
Yes.
I had spoken with the chairman during the break, and as you can see, it's 9:15 now, and we're still not quite complete with the HOPE application. My understanding is that it's the chair's intention to adjourn this case. We know that there's witnesses on both sides. There's no possibility of finishing it tonight, and quite frankly, I'm not even sure we can begin it tonight. And my understanding is that the case is going to be adjourned.
Yes.
When is the next date?
That I don't know. I'm going to ask Eileen, our secretary, to give it hopefully a priority date somewhere.
I'll have 4 things scheduled for the 25th. I only have 1 thing scheduled on the 2nd.
We're gonna adjourn.
This hasn't been heard though, right?
No, so that's, they would move, they would go in here. They would go before them.
How's October 2nd? Would that work for your witnesses?
I'll get back to you on, I believe so, I'll get back to you. I gotta check with the witnesses first, of course.
The witnesses that are not here, you mean, or?
Well, I could turn around.
Yeah, I mean, can we,
October 2nd? Let her know.
I mean,
Do we have any other cases on that night?
just FP Howell on the 2nd, but on,
And that's not really set in stone.
Can we go ahead and put them first if they are?
They would be first.
you
Okay.
could, but I just want to make sure that the witnesses are available. Give them priority.
Yeah, I'm good.
You're good? So we'll mark that without any further notice. for
October 2nd?
You'll be the first case.
Okay.
Okay. And extension of time, we're good?
They're good till December 12th.
Okay.
Thank you. Thank you.
Okay.
Have a good
Anyone in the audience for case number BA 17-13 Stavola Leasing LLC? This case will be carried to October 2nd, 7:30 PM with no further notice. Thank you. Okay. Give them a second to clear out here.
A lot of money wasted in NHS. It's,
Okay, begin where we left off.
Mr. Chair, I just want to make sure before we do closing arguments, were there any questions, any additional questions from the applicant, and did he rest his case? I just want to make sure.
Well, I think she's going to put her case on.
Well, I just want to make sure that his case is finished.
Yes.
Is that correct, Mr. Potter? Is there anything further on your side? I mean, obviously you have a chance to sum up. No further witnesses,
No
correct?
further witnesses.
Good. Any
Other
question?
than, since you have ruled that Ms. Van Brunt cannot testify,
Right.
All right, okay.
I've requested the chair to make.
respectfully reserve an objection on that, but
Okay.
that's the ruling of the chair.
It
Yes.
is my knowledge.
Yes.
No
I
seeing,
really don't want a witness that's not a professional is speaking towards the ordinances.
Okay.
Thank you.
so, Mr. Chair, unless there's any further questions, then the applicant's case is closed, and then we can proceed with the opposing attorney's case.
Correct. And it is still subject to cross-examination, correct?
Well, not the attorneys, though.
No, but, okay.
Yeah, in other
Got
words,
you.
unless they have witnesses, of course, which
Okay.
I don't believe they do.
No, we do not.
Okay.
Very good.
I just wanted to kind of summarize for the board the applicant's position with regard to our interpretation of the request that's being made by the applicant. What was specified and when I say applicant, I mean Mr. Potter and his client, as to the interpretation, I think the specific language that's used is that he's seeking to have a formal interpretation of this board as to 41 Randolph Road, our client's development application, that it meets the requirements as a, quote, permitted use within the scope of the SED zone, which he has referenced. He draws the attention of this board repeatedly to the purpose section, Section A of the ordinance. But respectfully, I would say that that is really of no relevance for this board to answer the question that's been before it, that's being requested of this applicant. The question is whether or not what is being proposed in the application is a permitted use. I think the language of Section 18879B, which sets forth in clear and unambiguous language in its title, permitted uses, and then lists, as Mr. Snyder indicated, 22 uses that are permitted within this SED zone, whether or not the application that's being sought falls under that section of the ordinance. There's a lot of talk about the purpose, the language within the purpose, it being defined as the preamble, it being defined as the intent of the governing body when it enacted the ordinance. Obviously, if it's defined as purpose, it's going to be setting the tone as to what would be the intent of the governing body. The question is whether or not that makes it part of the enacting act itself, part of the ordinance itself. Mr. Potter, alludes in his submission that I believe the board has, as well as ours and Mr. Snyder's. He draws reference to a Supreme Court case, PRB Enterprises Inc. 105 NJ1 versus South Brunswick Planning Board, and respectfully, I feel that case is more than clear to create the parameters for this board in its interpretation. The review, it clearly states in the case, the New Jersey Supreme Court states that their review of a purpose clause at issue in that case indicated that its function is different than the preamble. And that was tied in with the location of the purpose paragraph within the ordinance itself. It was within the body of the ordinance where it was addressing the uses. Here, the preamble as it's defined, the purpose, is in its own section. It is not within the section of permitted uses. While it is, as Ms. Apte indicated, it is something that it does demonstrate the intent of the governing body, it is not in any way a restrictive paragraph in the interpretation of this ordinance. It's very, very well written and very clear as to what the permitted uses are. This is one of the better ordinances that I've ever read for setting forth what the uses are. And I believe that there's really no question that while the purpose may define that the intent is to have economic development opportunities in areas of rail and highway infrastructure that are readily available, the fact remains that the use that's being proposed by this application is a permitted use listed within this ordinance in 188-79B. It is in subsection D, 1D of that, and so as to a matter of interpretation, I think the interpretation is clear for the board that that is the only question that's before this board. What's being proposed is a permitted use. This is not a non-permitted use. The township ordinance has a separate provision for conditional uses. There was some discussion by Mr. Potter in his submissions that this should be addressed as a conditional use. Well, he has set forth no testimony or no documentation before this board that what is being proposed is within that section of the ordinance. I believe that Mr. Pasolato conceded that it falls under the category that's listed here in subsection B. So the zoning board's role is it's your quasi-judicial in your function, and you review non-permitted uses. The planning board is the authority to be reviewing applications that are presenting a proposed use that is a permitted use under the ordinance. I believe the central question here is just about the construction of the ordinance, and specifically, while Mr. Potter wants to rely upon saying that this is the main intent and that the intent must be found within it, I respectfully disagree, and I feel that it's plain and clear for this board to find that the permitted use is here. The issue that Mr. Potter brought up with regard to the master plan, I don't believe that is an issue that the board needs to consider in its interpretation of this. Ms. Apte made clear that the reexamination report had been conducted in May with regard to the ordinances, and there's been no issue that's been presented at this time. That we're here now, 3 months later, so I believe that the applicant would have had ample time to review it and determine whether or not they felt that there was any additional question. And frankly, the only testimony that's been put before this board was that if it hadn't happened, then maybe this ordinance may be under shaky ground. So I don't believe that that's any expert testimony that the board would need to consider, that there is in fact an issue that the ordinance is in fact not consistent with the master plan. Lastly, Ms. Apte's report, she plainly has reviewed the applicant's submission as well as our application, and she does indicate that the proposed use that is within 41 Randolph Road's application is a permitted use. So I feel that the experts of the township are in agreement, and I feel that this board should have no problem in its interpretation that the permitted use, what's being sought as a review by the applicant here, is the outcome would be that the permitted use is within the ordinance, and therefore it rightfully belongs in the jurisdictional authority of the planning board. Thank you.
So what this board is called upon to do tonight is exercise its authority to interpret the township's zoning ordinance as it pertains to this particular application. That's a statutory power that the board has to determine, to interpret the zoning ordinance. No one disagrees that if the use is a permitted use, it belongs before the planning board. If the use is not a permitted use, it belongs before the zoning board. The only way for this board to sort of claw the underlying application away from the planning board would be to interpret the ordinance such that the warehouse
is not a permitted use in the SED zone. And I would respectfully submit that to do so, you would be defying the governing body that adopted the ordinance. And for reasons that have been said by counsel and that I'll repeat, I believe you'd also be defying the Supreme Court. Yes, the SED zone starts with a sentence that says, the purpose of the SED zone is to provide for a variety of economic development opportunities in areas of the township where rail and highway infrastructure are readily available. That's section A. Section B says permitted uses. And then it lists 22 permitted uses, A through V, one of which is the warehouse facility. Then it has design standards for solar energy generation facilities, which are one of the 22 permitted uses. Then it goes on to have accessory uses, as is typical, and then it goes on to have conditional uses. And we all know conditional uses are uses that are permitted only if you satisfy the conditions. If you don't satisfy the conditions, then it becomes a D variance, and you have to go to the zoning board. So for conditional uses, you might have bulk type variances that a planning board could give for a straight permitted use. But if it's a conditional use, you know, the setback or the minimum lot size, if those are conditions of the conditional use, you have to go to the zoning board to get a variance from those. Now, Mr. Pessimano testified that those permitted uses, those 22 uses where it says permitted uses, are only permitted under certain conditions. That condition being that you have this ready access to highway and rail, which he says means adjacent to, or you have an easement, or you can get an assemblage. He's turning the permitted uses into conditional uses. If it's only permitted if you satisfy that condition, then it's not a permitted use, it's a conditional use. But the ordinance has a separate section for conditional uses. And the conditional uses are telecommunication facilities and commercial breeders, dog kennels, shelters, pounds, dog training facilities, and pet shops. Mr. Pessimano, who seemed to believe it was worth taking up everyone's time to talk about how the Township's Planning Board had failed to adopt a master plan reexamination report without even bothering to call any of the township professionals to find out whether there was a reexamination report, and we now know that there was. He's saying that because the subject property does not have that adjacency to highway and rail, none of the permitted uses are permitted. You have to come to the zoning board. There's, under that interpretation, the township zoned this property so that you can't do anything with it. I guess you can continue a non-conforming use that existed previously, but you can't do anything else with it without coming to the zoning board. Who heard of such an ordinance where there's no permitted uses? At best, that prefatory language purposes indicates that the governing body, which surely knew what it was doing, it surely knew what land it was putting in the SED zone, it was satisfied that the lands in that zone had sufficient access to highways and to rail lines. Otherwise, it wouldn't have put it in that zone. The Supreme Court's decision in the case of PRB Enterprises, Inc., the South Brunswick Planning Board, I think requires as a matter of law that you reject the interpretation of the ordinance being put forth by Hope. In that case, the applicant went before the South Brunswick Planning Board for a Wawa. The Wawa was a listed permitted use, but the ordinance had a purposes provision very similar to the purposes provision here, and talked about it was intended to have these neighborhood businesses that wouldn't generate high amounts of traffic. And then it listed permitted uses. Planning board said, no Wawa. Yeah, it's listed as a permitted use, but you're going to generate too much traffic. You know what the court said? The court said, you can't use that preamble to get around the specific and unambiguous listing of permitted uses in the ordinance. You got your Wawa. That's what the court said, and the Supreme Court, the highest court in this state. But that's the argument they're putting forth. They're arguing that despite the unambiguous language, and even Mr. Pessimano acknowledged the ordinance was clear in terms of what are the permitted uses, doesn't matter that that's clear and unambiguous, because there might be differences of opinion as to what's readily available, and he might think it is, and this one might think it's not, and someone else might think something different. You know, you don't have the right to build it there. It's not a matter of right application. Just like the South Brunswick Planning Board said it's not a matter of right application, we can deny you because you don't satisfy the purpose of not generating traffic. The courts rejected it. So it's not a question of whether the SED zoning is a good idea or a bad idea. Respectfully, that's not for this board to determine. It's not a question of whether you'd like to see this warehouse here or would prefer that there not be a warehouse there. That's not a question for, within the purview of this board, with all respect. It's simply a question of whether the unambiguous listing of permitted uses somehow can become unpermitted based on someone's opinion as to whether it satisfies the purpose that the township, presumably the governing body, found it satisfied when it zoned it SED. Why would the township have zoned this property SED if it didn't satisfy the township's purposes? Either the governing body didn't know what it was doing, and I don't believe that was the case, or it believed that this property satisfied its stated purposes. So permitted use is a permitted use, and in this case, there's a permitted use, and the only interpretation that this board should give is that the 41 Randolph application is for a permitted use, and hence it stays before the planning board. Thank you very much.
Mr. Potter?
Thank you. The issue is whether or not this board has jurisdiction over the 41 Randolph development. That's the only issue, and this is brought up through the interpretation process. Now, you've heard the argument that the PRB versus South Brunswick Planning Board decision in 1987 ruled out of consideration the notion that the purpose clause has any function. It's simply surplusage. It's unimportant language. But 3 years later, in the appellate division decision of Trust Company versus Planning Board of, I don't know which township, the court said, the lower court judge also found that the 1986 legislation referring to the zoning ordinance, this is the decision of the appellate division of the Trust Company interpreting the PRB 3 years later. The preamble expressed an intent that the banks be included in Zone B. Plaintiff urges that we reject that finding, relying on PRB Enterprises, which this gentleman just pointed out was an important case. However, PRB does not hold that the preamble language of a municipal ordinance may not be used to infer the municipal intent. On the contrary, the Supreme Court held that the standard there expressed was intended to be substantive law, but was not precise enough to be effectuated. The court observed that a preamble traditionally sets up the conditions prompting the legislation, the conditions. We are satisfied that the 1986 ordinance expressly included lot number 13 and so on and so forth, and its preamble interpreted its zoning ordinance as one of the conditions for the ordinance. Further, the PRB court was clear that in determining whether an ordinance is adopted for an unlawful purpose, the courts must distinguish between the purpose of the ordinance and the motives. Let me skip over that. The court then addressed the nature of the municipality's true purpose. The aim of courts in construing zoning ordinances, like statutes, is to determine the legislative intent of the governing body. Where the construction of an ordinance is aided by references within it to the express intent of the ordinance of the governing body, it is this legislative directive which must govern. When confronted with ordinance provisions which are arguably inconsistent, it is the court's obligation to read them so as to make sense of them, and then to apply the ordinance in accordance with the intent of the municipality as expressed in the ordinance. Now, you have heard the testimony from Mr. Pasolano that it's clear and unambiguous that the intention of this, the purpose of this SED zone is to allow these 22 different uses, but only if they have ready access to rail and highway infrastructure. If they don't have that, then they belong in front of this board to determine whether or not to grant a variance from it. It does not mean that they can't build their project. It means that you, sitting as the jury for the municipality, you have it in your capacity as zoning board of adjustment members to determine how best to protect the public from the off-site impacts of a development. Planning boards have very limited control over off-site impacts. You, however, must weigh the impacts of off-site traffic and trucks going up and down two-lane roads and so forth. That is why you are the ones to make this decision pursuant to a transfer of the 41 Randolph application to the Zoning Board of Adjustment. I think that is the right decision, and it's one I think that the public of this township will honor and respect. Thank you very much.
Mr. Tropoli.
Now that the case is concluded, it's time for the board to render their legal determination. There are a few things that I would like to point out. First of all, that you as the finder of fact and finder of the law in this case have the right to accept or reject any part of the testimony that you've heard this evening. You can reject in all or in part the applicant's witness or that of your own professionals. But having said that, in terms of the statute, I must point out several things. First of all, Section 18879 lists warehousing and distribution as a permitted use. Mr. Schneider makes the point of saying had the applicant, strike that, had the township had a different view of things, perhaps they would have listed it as a conditional use. I do not want this board to arrogate upon themselves the right to change an ordinance if you feel you have that ability to do so. You do not. If it's a permitted use, it says permitted, that's what it is. It's a very fine legal determination that the applicant's asking you to make. What they're saying is that unless these uses are adjacent, immediately adjacent to a infrastructure or highway, that these belong to the, as a matter for the zoning board. That's a determination that you have to make. Is that what the township's legislative intent was by listing 22 things here, one of which is warehousing and distribution as a permitted use, but only permitted in certain conditions? If then, why not list it as a conditional use? Whether or not it's correctly in front of the planning board or not. That's an issue that you have to also determine as you move forward. That's what the applicant's asking you to do, to take what's listed as a permitted use, to find that it's permitted only in some very strict and limited circumstances. You've heard the testimony of Mr. Mallon. Mr. Mallon is giving you a historical view of how ordinances were presented in the township. He had mentioned collector roadways. He had mentioned some very specific things. And it was his testimony that the township would have listed something specifically if they had intended to have the term to be interpreted as adjacent. There was some discussion about PRB Enterprises versus South Brunswick, Inc., which is a appellate division case from 1985, affirmed ultimately by the Supreme Court in '87. And Cox brings out that it says that nor is the meaning or intent of an ordinance to be gleaned from the general statement of the purpose of the ordinance, introductory to the regulatory provisions thereof, where the regulatory part is expressed in clear, unambiguous terms. And that's what you need to decide. Is the ordinance clear and unambiguous with respect to that? And what weight do you give the purpose clause? So as you make your determinations, you need to look at the legislative intent, you need to look at the historical intent, the way that this town has come forward with its ordinances. You look at the ordinance as a whole. It's up to you to weigh and judge whether or not the purpose relates in a fashion that the applicant is wishing that it be considered. There are specific provisions in this ordinance which, can you reject the fact that the township has ruled that warehousing and distribution is a permitted use? Is that a primary function of the zoning board, or is it to address variances and the like? You have to look at things narrowly. Look at the ordinary meaning of words. Your decision really is limited to what the applicant has requested from this board. I don't want to belabor the point, but those are some of the things that you have to consider. You have to consider how these ordinances were looked at in the past. Consider case law, the PRB case, cases that council's brought up, and whether or not had the township intended to have this as a conditional use, which would have been before the zoning board, that they would have in fact made it as such, instead of placing it in section 18879 of the ordinance as a warehouse and distribution permitted use. So those are some of the things as you do your deliberations that I'd ask that you keep in mind. And again, your narrow focus on the legal issue only. So your fact-finding will be based on legal fact-finding, interpretations of the ordinance, and again, not on the merits of the case, not on its impact on the area, but whether or not it's properly to be considered a planning board case, Mr. Chairman.
Thank you. Any questions from the board to our professionals to clear up anything in your mind, or? Mr. Amata? Okay. What's the pleasure of the board?
Mr. Chair, members of the board, when I look at a zone and a zoning, looking at the ordinances, I look at the whole ordinance, which means the introduction, the preamble, and what is permitted. When looking at something like a residential, be an introduction saying this is a residential, it'll state the properties, it won't state the size, but it'll state the characteristics, and then followed by what would be permitted. It's the language which I believe is in question. What is readily available, what is available? My interpretation, readily available, is something that is close to a commercial highway, a Route 9, a 195, a Route 33. Whereas available, yeah, you can have a warehouse that's 5 miles away from a commercial, but it's still available. The rail, I don't know what the condition of the rail is. Is it just a rail that's passing by? Is there a station there? We don't know and can't make the judgment now. But the fact is, it says readily available, and it looks like where this warehouse is proposed might not be readily available. It just might be available, but it's not readily available. And I believe that when you looked at the conditional uses in the ordinance, it was pet shop, a breeding. They might not use trucks. They might use a car to move something by. But really, it's readily available, and I don't see where this location is as being readily available. So my opinion, I believe that we should be looking at this.
The thing of it is warehouses is a permitted use in the zone.
It's a permitted use, exactly. But in Section A,
Yeah, but
it
Section
says,
A is not,
but it's an introduction. The thing is, if we didn't have introductions, then you could just put an ordinance and say permitted use SED, permitted use residential, and you don't need an introduction. But here, it's an introduction is stating what the purpose of this ordinance is going to be.
purpose.
The purpose
Okay.
of this ordinance, and part of the purpose is readily available. But that's my opinion, whether the board agrees or not. That's the way I see it. Even though it is permitted, there is a section before that stating the whole idea of the SED. And part of it is readily available highway and rail. The town council could have not put that at all and said a permitted use in this area. But they put readily available highway and rail, so that's part of the whole ordinance.
Mr. San Clemente, are you making a motion, or are you just giving your opinion?
I'll make a motion for that. And again, it's up to the board whether they agree with me or not.
If I could just have clarification on exactly
Yeah.
what the motion is.
Yes.
The motion would be that we would hear, the zoning board would hear the case as opposed to the planning board.
Do I have a second?
want to second that. I think his interpretation of what is in that ordinance has got to be taken as a whole and not just piece the part that you like. It's the governing body has that other statement in there, which is part of the ordinance. And we would be remiss if we didn't read the whole ordinance and take it to heart. That's my opinion.
Okay, got a motion and a second. Can we get a roll call, please?
Mr. Armato?
Yes.
Mr. Cordelicchio?
No.
Mr. Mertens?
No.
Mr. O'Donnell?
No.
Mr. Posh?
No.
Mr. San Clemente?
Yes.
Chairman Nansen?
No.
Motion's denied.
Okay.
Lose again.
So we're done?
Is that the vote?
The vote,
No,
motion failed.
it failed.
Okay. Thank you very
5
much.
to 2.
You're welcome.
The applicant was denied.
Thank you for your patience and your
Yes,
hard
sir.
work.
Damn thing.
Mr.
Much
Potter.
appreciated.
You just can't say, well, okay, guys, go ahead.
Yeah, I mean,
There'll be a written statement to,
there'll be a resolution at some point, yeah.
how about in the next 24 hours?
No.
Yeah, I mean, there's no point in application.
But anyway, okay, is any other further business before the board? Mr. Mallon, Mika, Ron,
Oh, no, I'm sorry.
everything cleared? Okay.
Comment.
Motion to adjourn.
So moved, Mr. Chairman.
Motion by Mr. Cordelicchio,
Second.
second by Mr. San Clemente. All in favor?
Aye.
All opposed? Board adjourned,
I'm not speaking to anybody,
9:50.
especially you.